Welcome to this video on protected information in public records. This training was produced by the State Electronic Records Initiative in coordination with the Council of State Archivists. Its purpose is to help those who maintain electronic records understand the types of information contained in public records that must be protected by law. We hope that this video not only helps you understand the risks of disclosure of protected information, but also how to mitigate that risk. In most United States jurisdictions, there is an established legal process for accessing public records. For the federal government and some states, this is known as the Freedom of Information Act, aka FOIA, which outlines the mechanisms for applying for, granting, and denying access to public records. In other jurisdictions, it may have a different name, such as Public Records Law or an Access to Records Law. Typically, the law favors open access to records. After all, public information belongs to the public. But often there are exemptions to this general access, and these vary considerably by jurisdiction. Some common exceptions are to protect public safety, personal health information, and intellectual property. One of the primary functions of government is to collect data in order to efficiently and effectively perform its legal duties. This includes collecting data about citizens, corporations, and more. This collection, sometimes intentionally and sometimes unintentionally, includes sensitive information, such as health information or industry trade secrets. Much of this information, if disclosed in an unauthorized manner, could be personally or financially damaging to individuals or the public at large. While most public records may, by law, be freely accessible to the public, there are some specific pieces of information that should not be shared freely. Personal identity information, including Social Security numbers, and health information are the most common, but there are many more that may be protected by law. Typically, the record's custodian is responsible for the protection of this information. This responsibility begins with the record's creators, but, in the case of permanent records, will eventually fall on the archives as the record's final custodian. As some of these protections last indefinitely, so too does the responsibility for protecting them. For the purposes of this presentation, we discuss these rights and protections very broadly, since laws and regulations vary across the U.S. One major category of protected rights is intellectual property, which is broadly defined as the output of the human mind. Intellectual property falls into four main categories: patent, trademark, copyright, and trade secrets. While each of these are protected in specific ways, typically the unauthorized disclosure or copying of such information is prohibited, as it would cause harm to the holder of that intellectual property. In the rare cases where government archives acquire privately created materials, donation agreements should stipulate ownership and any provisions for access or copying. Another major category of protected rights deals with personal privacy, which has been addressed in numerous pieces of legislation and case law. The definition of personal or personally identifiable information varies significantly from jurisdiction to jurisdiction. The federal government's Office of Management and Budget provides a fairly simple baseline definition, which we have provided here. However, to what degree to protect such information and for how long is often unique depending on the jurisdiction, information, and records in question. A third major category of rights to be protected is personal health information, aka PHI. Many of the laws pertaining to the protection of health information come from the 1996 Health Information Portability and Accountability Act, HIPAA, and subsequent rules. HIPAA defines the type of information and the requirements for those with custody over such information in great detail. The last major category of federally protected rights are those of student educational records. These records are likely to be permanently retained by the government and contain a great deal of personal information. Similar in nature to personal information and health information, educational records are explicitly addressed in federal law. These have been just a few common examples of information and the rights of citizens that need to be protected from unauthorized access and disclosure. Now we shall discuss how to manage this information. How can an archivist protect these rights? The first step is to identify which rights need to be protected, and what the legal requirements for those rights are. Most archival institutions will likely have policies in place that cover access to sensitive or protected material. Assistance from the record's creators or counsel can be greatly helpful in articulating requirements, as they are best placed to understand the types of information they collect, create, or utilize. Next is to identify those records which contain, or are likely to contain, these categories of information. And finally, the last step is to apply restriction information to the records themselves, through their metadata or other classification methods. This way, future archivists, records custodians, and those seeking access to records will be able to determine easily if records are likely to contain any protected information. Typically, the same laws that authorize or create governmental programs outline the requirements for the protection of information collected or created by those programs. But this is not always true. There will, over time, be a patchwork of overlapping legal requirements from many different sources that apply to records. Sorting out these requirements is typically the work of records managers or records and legal analysts. Policy or workflows can also impact the collection of protected information. As an example, the law may not explicitly list a particular function as collecting Social Security numbers, but if that function begins to collect Social Security numbers, that agency must apply any legal protections that apply to Social Security number collection. Thus, archivists must be aware of both the explicit requirements as well as the implicit ones. There are two ideal opportunities for capturing access information. The first is during the record's creation or receipt. Likely the record's creator will be the most knowledgeable about their content. This process need not be manual. Automatic metadata generation and labeling according to policy are common records management techniques. The government can often set standards on what records and information it will receive, and more importantly, how it is received. Requiring the identification of protected information through a declaration can ease the state's burden and allow its creator to properly identify information. The second is during the transfer or accession into the archives. It is much more costly in terms of time and staff resources for archivists to chase down the information in individual records. Capturing rights information in record metadata is strongly recommended, as it provides a clear label on records of the nature of information contained therein. For a baseline, information captured in metadata should include any identified rights or exceptions, any requirements for those rights, and any relevant citations for laws, licenses, and other legal instruments. Thus, if a record contains copyrighted material, it could be identified and have relevant copyright laws cited. While some categories of information may need to be protected indefinitely, as defined by law, many forms of protected information remain protected for a discrete period of time. Archivists and records managers can use the aforementioned strategies, such as recording protected information in the record's metadata, to be able to resurvey accession collections many years after the fact, and perhaps make available records which at one time were closed. Additionally, other scenarios can offer avenues for disclosure or provision of access to records containing protected information. Some information can be shared with permission of the rights holder, e.g. some forms of health information, while others, like copyright and other forms of intellectual property, have robust legal frameworks defining what kinds of uses are permissible, and which ones require explicit permission from the holder. A thorough understanding of federal, state, and local laws, regulations, and rulings is essential to determine the long-term preservation and access environment for records containing protected information. Access information does not need to be complex, and there are a number of schemas that capture this information in a standardized way. The most important thing is that the correct access information is included to make sure that all legal requirements are satisfied. It is best to pair the identification of protected information with the policy on access, copying, and other usage. For example, if a permanent record has personal information in it, and the law requires it to be protected until 50 years after the record's receipt, then pairing rights and metadata with a date of creation can provide a clear indicator on when the records will become broadly available. This concludes the SERI education video regarding the protection of rights in archives. We hope this has provided a general overview of the kinds of information to be protected, and a simple framework to assist in the identifying and protecting of that information. This training was produced by the State Electronic Records Initiative in coordination with the Council of State Archivists. The Council of State Archivists is a nonprofit membership organization of the state and territorial government archives in the 50 states, 5 territories, and the District of Columbia. COSA began the State Electronic Records Initiative project in 2012 to address the long-term care and access of electronic records. For additional resources on electronic records preservation and management, please visit the State Electronic Records Initiative webpage.